You're listening to the Valley Current.
Elon Musk, right? Sitting right there in a federal witness box.
Yeah, in Oakland.
Exactly, Oakland, California. And the date, because we really need to ground you in exactly when this is happening, is Wednesday, April 29th, 2026.
Right.
And he's just quietly, methodically weaponizing this $38 million seed check against, well, literally the most highly valued artificial intelligence company on the planet.
Which is just a wild scene to visualize.
It really is. I mean, he's looking right at a jury claiming the defendants straight up stole a charity.
Yeah.
But the crazy part is the most compelling thing in that room isn't the staggering amount of money. And it's not even the clash of these massive Silicon Valley egos.
No, it's the clock.
Yes. The ticking digital countdown clock mounted right there in the courtroom. It's ruthlessly dictating every single second these lawyers have left to speak.
It completely changes the dynamic.
Totally. So welcome to the deep dive. We are taking you straight into the nerve center of Musk v. Altman, specifically day 2 of this massive trial.
And to really decode this highly complex legal chess match that's playing out, we're relying on a pretty robust stack of sources today.
Right. Our main roadmap is this incredibly granular newsletter. It's the Computer Law Group LLP Trial Update.
Authored by their managing partner, Jack Russo. It is just a fantastic, detailed Day 2 recap.
Yeah, Russo really gets into the weeds. And we're also weaving in, supplemental reporting from Law 360, Reuters, and pulling from the actual public court dockets.
Just to make sure you're getting the absolute complete picture of what's going on.
Exactly. Because the mission for our deep dive today is to really separate the theatrics from the actual legal architecture of the case.
Right, because if you just read the headlines, it really just looks like a standard clash of billionaires.
Just egos colliding.
Exactly.
Yeah.
But when you examine the source material, what is actually happening in that room is, well, it's a masterclass in trial strategy.
Oh, absolutely. We're watching this real-time demonstration of how credibility is manufactured for a jury.
And how can be instantly destroyed by a judge.
Yeah, that part is fascinating. Plus, there's this incredibly dangerous intersection where corporate marketing collides with trademark law and, fiduciary duty.
So much to get into.
Okay, let's unpack this. We should probably set the parameters of the battlefield first so you can really visualize the constraints these legal teams are working under.
Yeah, that's crucial.
So we're in the Northern District of California, and sitting in the jury box is a 9-person advisory jury.
Specifically, I think it's 6 women and 3 men.
Right, and they are seated under Federal Rule of Civil Procedure 39C, which we'll get into later.
It's a very important distinction.
Definitely. And presiding over all of this is Judge Yvonne Gonzalez-Rogers. And she is running this trial with an absolute iron grip.
She really is. And she's the one utilizing that strict liability allocation countdown clock you mentioned.
Yeah, let's talk about the exact time limits, because it's 22 hours for Musk, 22 hours for OpenAI, and get this, just 5 hours for Microsoft.
Which is wild. And that strict time allocation, it completely alters the physics of a trial.
How so? What does that actually change for the lawyers in the room?
Well, in an ordinary setting, litigators might spend hours, meandering through the background of a witness.
Right, like building a slow, comfortable rapport.
Exactly. Or they might just bury the opposing side in endless, repetitive cross-examination questions just to wear them down.
Ah, right. Just a war of attrition.
Right, but when a judge imposes a strict chess clock like this, every single word has a tangible cost.
Oh, wow.
Yeah, I mean, if you spend 15 minutes objecting to some minor piece of evidence, you have just burned 15 minutes of your own time that you cannot use later for your closing argument.
That is so stressful. So it creates this environment of intense pressure.
Highly intense. The lawyers have to distill their arguments down to their absolute purest, most potent form. There is no room for filler.
Which perfectly brings us to the core thesis of the Day 2 reporting. Because the consensus from all the trial updates is that Day 2 squarely belonged to Elon Musk.
It really did.
But the reason why is the real twist here. Because he didn't win the day, because his lawyers delivered some cinematic knockout punch during a cross-examination or something.
Right, it wasn't a few good man moment.
Exactly. He won the day because OpenAI's defense lawyers walked straight into a trademark trap of their own making.
And crucially, They did it in front of a judge who has a notoriously zero-tolerance policy for logical contradictions.
Yeah, we have to get to that post-jury intervention by the judge because it is easily the pivotal moment of the day.
Definitely. But to understand the gravity of that misstep, we first have to examine the psychological foundation that both sides spent the entire morning trying to build.
Right, the dueling narratives, because trials are fundamentally about competing realities.
Exactly. Before you introduce a single contract or a single technical document to the jury, you have to sell them on the lens through which they should view those documents.
Okay, so let's explore how Musk's team is constructing their reality. Musk is represented by Mullo Lamkin, LLP.
And Stephen F. Mullo is leading the arguments in the courtroom.
Right, and when you read the transcripts of Mullo's strategy, it is entirely stripped of the usual corporate jargon.
It really stands out.
Yeah. I mean, if you walk into the Delaware Chancery Court, you sort of expect to hear lawyers droning on about, like, corporate conversion statutes, right?
Oh, yeah. Fiduciary tranches, esoteric nuances of corporate governance, all that dry stuff.
Exactly. But Mullo just abandoned all of that. He transformed this highly technical dispute into a very simple, visceral morality play.
And it is an incredibly shrewd translation of complex law into human emotion.
Because juries don't want the dry stuff, right?
Exactly. Juries generally do not want to be lectured on the mechanics of corporate restructuring. They want to know who the victim is, who the villain is, and what was taken.
Makes total sense.
So by framing the entire lawsuit as a case of a stolen charity, Mullo taps into this universal sense of right and wrong.
Because a charity implies something built for the public good.
Right, something selfless. So when you accuse someone of stealing that, you aren't just alleging a breach of contract.
You're alleging a moral transgression against society.
Yeah, exactly.
And the language Mullo used to cement this was so vivid. He literally stood in front of those 9 jurors and explicitly said the defendants stole a charity.
Very powerful phrasing.
But the line that really stuck out in the reporting, and I love this analogy, was how he described Microsoft's entry into the OpenAI ecosystem.
Oh, the Picasso analogy.
Yes. Mullo said it was as if the museum store sold the Picassos so they were locked up where no one could see them.
Let's dissect the mechanics of that analogy, because it is doing a tremendous amount of heavy lifting for the plaintiff's case.
Okay, break it down for me.
Well, by comparing artificial intelligence to a Picasso, Mullo accomplishes 2 things right off the bat.
First,
he elevates the underlying code from a mere commercial product into an irreplaceable artifact of human achievement.
oh, wow. I didn't even think of it like that.
Yeah. And second, a museum is a place of public trust, right? It's open to everyone, much like the original open source ethos OpenAI champion.
Right, so the museum store represents the commercialization aspect.
Exactly. So the imagery of the museum store selling off the actual masterpieces to be locked in a private vault, it perfectly encapsulates the plaintiff's core allegation.
Which is that a public good was secretly privatized for exclusive corporate gain.
Bingo.
That imagery is incredibly sticky for a jury. But, it also leads to a procedural question that I think anyone following this would ask.
What's that?
So, Musk took the stand and aggressively mirrored Mullo's language. According to the reports, Musk testified under oath that an OpenAI win would set a precedent for looting every charity in America.
He did say that, yes.
Wait, can a witness just sit on the stand and accuse the other side of looting? I mean, isn't that a legal conclusion?
It absolutely borders on one, yeah.
Right, because you would expect the defense to immediately object to a witness essentially acting as the jury and using criminal terminology.
And the defense did object exactly as you would expect.
Okay, so what happened?
Well, the rules of evidence generally dictate that a lay witness is there to testify to matters of direct personal fact.
Like what they saw, what they heard, what they did.
Exactly. They are not permitted to offer legal conclusions or instruct the jury on the downstream societal precedents of the case.
So when Musk uses the word looting,
he is undeniably characterizing the defendant's actions using criminal terminology.
So why didn't the judge strike it from the record? The reporting indicates Judge Gonzalez-Rogers denied OpenAI's motion to strike that testimony.
And the judge's rationale is what makes this a brilliant tactical victory for the plaintiff.
Really? How so?
The judge ruled that Musk is not a lawyer. Therefore, the jury understands that he is not offering a binding legal definition of looting.
Oh, I see.
She reasoned that he is simply expressing his deep, personal, subjective opinion about what happened to the company he helped found.
Wow. That feels like the judge unintentionally handed Musk a massive microphone.
It does more than that, actually. It authenticates his emotional state to the jury.
Because he's getting visibly upset about it.
Think about it. When a lawyer objects to a word like looting, and the judge essentially says, let him speak, he's just giving his personal perspective, it signals to the jury that Musk's outrage is genuine.
He doesn't sound like a highly coached, sterile corporate executive reciting a sanitized script.
Exactly. He sounds like a founder who feels profoundly betrayed.
Right.
And that allows the moral framing of the entire lawsuit to really permeate the courtroom under the protective guise of a witness's emotional state.
That makes perfect sense. So Musk is playing entirely to the heart, leaning heavily on the morality of the situation.
Very effectively, yes.
Let's rotate the board and look at the counter-narrative OpenAI is deploying. Their defense is led by William Savitt of Wachtell Lipton.
And to give you some context on the firepower here, Wachtell is one of the most feared corporate litigation firms on the planet.
Yeah, Savitt himself is the attorney who successfully compelled Musk to close the Twitter acquisition back in 2022, right?
Yes, he forced Musk's hand in the Delaware Chancery Court.
Right.
So they have definitely tangled before.
That historical context is so critical.
It really is. Wachtell Lipton thrives in environments like the Delaware Chancery Court or the Southern District of New York.
Right, those really formal jurisdictions.
Yeah, where cases are typically decided by highly specialized judges' bench trials, where the arguments revolve around dense financial forensics.
So they are accustomed to persuading legal scholars, not necessarily a 9-person advisory jury composed of everyday citizens in Oakland.
Exactly. And the strategy Savitt chose for this jury is, well, it's aggressive.
Very. In his opening statement, he framed Musk's entire 2024 lawsuit as nothing more than sour grapes.
Which is a bold framing.
Right. Savitt's narrative is that back in 2021, Musk attempted to seize unilateral control of OpenAI.
And when the board rebuffed that attempt, Savitt claims Musk threw a tantrum.
Yeah, he literally told the jury that Musk literally grabbed his stuff and stormed out.
The defense's theory is that this current litigation isn't about protecting humanity at all.
It's just Musk trying to legally paralyze a competitor because he has since launched his own AI venture, XAI.
What's fascinating here is that this approach relies heavily on characterological advocacy.
Characterological advocacy. What does that mean exactly in practice?
Instead of primarily attacking the timeline or the specific clauses of a contract, Savitt is attacking the psychological stability and the underlying motives of the opposing party.
Ah, got it.
He is trying to establish a character archetype for the jury. The vindictive, opportunistic billionaire throwing a tantrum because he didn't get his way.
But, I mean, it seems incredibly risky to base your opening argument on the emotional instability of your opponent.
Why do you say that?
Well, you are setting an expectation for the jury, right? If you tell them the plaintiff is an unhinged, tantrum-throwing opportunist, the jury is going to wait for that version of the plaintiff to show up on the witness stand.
And that is the precise vulnerability of characterological advocacy. You establish a credibility ceiling for your own narrative.
Right.
If you promise the jury a volatile, irrational opponent, and then that opponent takes the stand and projects calm, measured, principled resolve.
Which is exactly what Musk did on day 2.
Exactly. Then your entire opening statement retroactively looks like a theatrical exaggeration.
It just makes Savitt look like he was overpromising.
Yes. Based on the day 2 reporting, that is exactly the vulnerability Musk exploited.
Which is crazy because the actual law is on Savitt's side, right?
Well, the core legal theories Wachtell is relying on, the argument that a charitable trust cannot be enforced in this manner, or that the statute of limitations has simply expired, are robust, highly defensible legal positions.
They buried them.
Right. By wrapping those solid legal theories in the hyperbolic rhetoric of tantrums and sour grapes, the defense took an unnecessary risk with the jury's perception.
So the clash of the opening narrative sets the table. But the trial updates make it super clear that the day was won through specific, concrete details during witness testimony.
Absolutely.
So how did Musk actually fortify his stolen charity narrative once he was sworn in and sitting in the box?
He achieved it by utilizing extreme specificity, contrasting sharply with the broad rhetorical strokes the defense used.
Okay, give me an example.
Well, in his opening, Savitt attempted to undermine Musk's financial commitment by mocking a broken pledge of $1 billion.
Right, implying Musk overpromised and underdelivered.
Exactly. But Musk countered this on the stand, not with anger, but with an exact, undeniable figure.
Right. He proudly pegged his actual realized initial investment at $38 million.
Which is brilliant.
Yeah, $38 million in seed capital is a staggering figure to drop in front of a jury. It grounds the entire abstract dispute into a very tangible reality.
It creates an anchor point. And Musk used that financial anchor to methodically list his contributions.
Like what else?
He testified that he originated the idea, he came up with the name OpenAI, he personally recruited the foundational scientific talent.
And he provided the crucial initial funding to get the lights on.
Exactly. But the most vital piece of testimony was his assertion regarding the corporate structure.
Oh, this was fascinating. He explicitly told the jury that he had the resources and the ability to start OpenAI as a traditional for-profit technology company from the very first day.
He could have done it just like Tesla or SpaceX.
Right. But he testified that he consciously and deliberately chose the nonprofit route because the mission was paramount.
He is laying the foundation that he is the true architect of the original vision.
And to bolster that, he introduced these highly specific anecdotes that function almost like character witnesses for himself.
The reporting highlights a really interesting story he told about Larry Page.
The co-founder of Google, right?
Yeah. Musk described a birthday party in Napa Valley back in 2013. This is actually corroborated by Walter Isaacson in his biography of Musk.
Oh, wow. So it's documented.
According to the testimony, Page criticized Musk during this party, calling him a speciesist.
Because Musk was overly concerned with protecting humanity from the potential dangers of AI.
Right. And we really have to evaluate the psychological impact of that specific anecdote on the jury.
It's basically Musk isolating himself from the rest of the Silicon Valley establishment, isn't it?
Exactly. He paints the leaders of companies like Google as technologically reckless, driven by progress without sufficient regard for human safety.
And the term speciesist is particularly effective.
Why do you think so?
Because it implies that caring about the survival of the human race is viewed as, like, a quaint, outdated bias by the other tech titans.
Spot on. It positions Musk as the lone, principled sentry standing at the gates, protecting the public from unregulated AI development.
He also utilized a sidebar anecdote involving Microsoft that felt incredibly calculated.
Oh, the Satya Nadella story.
Yes. While on the stand, he just slipped on a claim that Microsoft CEO Satya Nadella had previously told him that Microsoft was only in this thing, meaning the broader AI space or the OpenAI partnership, because of Musk's involvement.
Comes across as name-dropping at first glance.
It totally does. Like, oh, Satya and I were just chatting.
Right, but it serves a very distinct purpose. He is attempting to prove that his presence was the indispensable gravity that held the entire OpenAI ecosystem together in the early days.
Ah, the indispensable gravity. That makes sense.
Because that perceived indispensability is the necessary setup for his explanation of why he left.
Right.
If you put yourself in the shoes of a juror, you are trying to understand the emotional timeline here.
You are asked to imagine initiating a project, providing $38 million in funding, recruiting the team.
And operating under a strict nonprofit humanitarian banner.
Right. And then, according to Musk's testimony, years later, your partners approach you and demand equity stakes in the venture.
Exactly. Musk testified that he found Sam Altman and Greg Brockman's 2017 demands for equity to be unfair and inappropriate.
He stated that he told them to go start their own separate company because he had had enough.
When you lay the timeline out with those specific details, the defense's narrative that Musk simply threw a tantrum and stormed out suddenly looks very different.
It totally does. It transforms a supposedly erratic walkout into a principled resignation over the violation of the founding ethos.
Right. It provides a logical, morally consistent alternative to the defense's theory.
But the documentary record from that era is highly contested, isn't it?
Oh, absolutely. There are emails from late 2017, authored by Musk himself, that the defense will absolutely utilize.
And those emails suggest Musk was exploring the idea of a for-profit conversion himself, right?
Yes, in order to generate the massive capital required to compete with Google's DeepMind.
Okay, so both legal teams are going to parse the wording of those emails endlessly.
Without a doubt. However, by anchoring his time on the stand in concrete financial figures, specific interpersonal conflicts, and a steadfast philosophical narrative,
Musk really managed to present a highly compelling, coherent story to the jury on day two.
He absolutely did.
Okay, so that sets up the dynamics perfectly. But here's where it gets really interesting.
The post-jury intervention.
Yes. The entire complexion of the day shifted the moment the jury was escorted out of the room.
Because Savitt's opening statement relied heavily on portraying Musk as an opportunist.
Right, and to do that, Savitt downplayed the importance of OpenAI's original open source mission.
He implied to the jury that the name of the company wasn't inherently tied to a rigid, legally binding open source mandate.
Just kind of a catchy name.
Exactly. But according to the trial updates, the instant the jury doors closed, Judge Yvonne Gonzalez-Rogers intervened and completely derailed that strategy. This colloquy, the conversation between the judge and the lawyers without the jury present, is the critical pivot point of the trial so far.
Yeah, the judge pulled Savitt aside and pointed out a glaring contradiction.
A massive one.
She noted that Savitt's attempt to minimize the meaning of the word open in OpenAI directly contradicts the sworn foundational legal arguments that OpenAI has made in a completely separate recent trademark dispute.
If we connect this to the bigger picture, to fully grasp the magnitude of this legal collision, we have to examine the mechanics of trademark law.
And how corporate strategies can fatally intersect.
Exactly. The case the judge was referencing is OpenAI, Inc., Open Artificial Intelligence, Inc., and Guy Ravine.
Which was a high-stakes trademark infringement lawsuit.
And crucially, it was presided over by this exact same judge.
Oh, wow, right. Jack Russo's trial update newsletter dedicates a significant amount of analysis to the intellectual property law at play here.
It's vital context.
Let's break down the Lanham Act. Specifically, Section 2E1. What does this statute require, and how did OpenAI's IP lawyers navigate it?
Okay, so the Lanham Act is the primary federal trademark statute in the United States.
Right.
Under Section 2.1, the United States Patent and Trademark Office categorizes the strength and registrability of trademarks along a spectrum.
Okay, making sense so far.
If a trademark is considered merely descriptive, meaning that consumers immediately understand that the name simply describes a feature, function, or characteristic of the product, it is generally not afforded trademark protection.
So you can't just trademark the word apple if you sell actual apples.
Precisely. To overcome that hurdle, a company must prove that the name has acquired secondary meaning.
Meaning the public has come to uniquely associate that descriptive term with their specific brand over time.
Exactly. In the Ravine case, OpenAI was represented by a different, highly prestigious law firm, Quinn Emanuel.
Right, Quinn Emanuel.
To win that trademark monopoly, Quinn Emanuel had to legally embrace the concept of descriptiveness.
Wait, so they couldn't just argue that OpenAI was a random, catchy, arbitrary word they invented?
They absolutely could not. The historical record at the Patent Trial and Appeal Board, the PTB, shows that OpenAI actually had trademark applications rejected in 2022 and 2023.
Really? Why?
Specifically because the examining attorneys found the term open to be highly descriptive of open source artificial intelligence.
Oh, wow. So they were stuck.
Right. So to navigate this, Quinn Emanuel leaned into the descriptiveness to prove secondary meaning.
They just owned it.
They submitted formal arguments to the government stating that the word open literally described the open, public-facing quality of their original AI services.
And to prove this to the Trademark Office, they actually submitted OpenAI's own founding charter.
Yes. They utilized their public, mission-driven identity as an open-source entity as the foundational legal evidence to secure their intellectual property rights.
Okay, let me push back and explore the counter-argument here, because I think a casual observer might wonder why this is such a catastrophic issue.
Fair point.
We are talking about two different areas of law, right? One is an intellectual property dispute about brand confusion.
Yes.
And the current trial is a complex commercial dispute involving fiduciary duties and breach of contract.
Right.
Plus, they are being argued by two completely different law firms. Quinn Emanuel handled the trademark. Wachtell is handling the trial.
So what's the problem?
Exactly. Why can't Wachtell simply pivot? Why are they not allowed to argue to this jury that the name is just marketing, even if their IP lawyers argued something different to the Trademark Office years ago?
The barrier preventing that pivot is the doctrine of judicial estoppel.
Judicial estoppel.
Yes, it is an equitable principle designed to protect the integrity of the judicial process.
How does the mechanism work?
It's straightforward. If a party successfully assumes a certain factual or legal position in one legal proceeding, they are strictly prohibited from assuming a contrary position in a subsequent proceeding simply because their strategic interests have changed.
Wow. So you can't talk out of both sides of your mouth.
Exactly. You cannot utilize the machinery of the federal government to secure a lucrative trademark monopoly by swearing that your company's name literally embodies your foundational open source mission.
And then walk into a federal trial court, look a jury in the eye, and argue that the word open was merely a flexible marketing term.
Right, just because that new narrative is convenient for defeating Elon Musk's lawsuit.
It undermines the entire truth-seeking function of the court.
It treats the court as a tool for convenience rather than an arbiter of facts.
That makes a lot of sense.
And the danger is magnified exponentially because they are attempting this pivot in front of the specific judge who handed them their previous victory.
Oh, man. Judge Gonzalez-Rogers presided over that trademark case, too.
She did. She granted OpenAI a preliminary injunction based on those exact arguments.
And she ultimately granted them complete summary judgment in 2025, right?
Yes. She absorbed their narrative, she validated it, and she awarded them the trademark based on the premise that their story was true.
So for OpenAI's trial lawyers to now attempt to walk away from the very premise they used to win her over in the prior case
is legally perilous.
Yeah, legally perilous is putting it mildly. To understand why this trademark contradiction represents a systemic threat to OpenAI's entire defense strategy, we have to look closely at the jurist sitting on the bench.
The trial updates emphasize that understanding Judge Yvonne Gonzalez-Rogers is just as important as understanding the case law.
The reporting highlights a critical aspect of her judicial philosophy, right? Jack Russo's update refers to it as her credibility ledger.
Her credibility ledger, exactly. When she logs a factual representation from a party, she holds them to it permanently.
And the newsletter specifically invokes the ghost of a massive precedent to illustrate this, the Epic Games v. Apple trial.
Yes.
This occurred in April 2025, and it is a defining moment for this judge.
Yeah.
Can we explore the mechanics of what happened in that case? Because it clearly illustrates the danger OpenAI is currently courting.
The Epic Games v. Apple litigation is a vital context here. During those proceedings, Judge Gonzalez-Rogers determined that Apple had not merely made an error in compliance,
right,
but that they had engaged in an active, intentional obfuscation of the truth to thwart a court-ordered injunction regarding their App Store practices.
And her response was devastating, wasn't it?
Completely. She didn't just issue a fine or a stern warning. She found that Apple committed an obvious cover-up.
Wow.
And she referred both the corporation and a specific Apple vice president to the United States attorney for a criminal contempt investigation.
Referring an executive of a multi-trillion-dollar company for criminal contempt is the absolute nuclear option for a federal judge.
It is exceptionally rare, and the Ninth Circuit Court of Appeals largely upheld her actions later.
So she does not mess around.
It demonstrates a judge who is absolute in her demand for institutional honesty. She views contradictions not as clever lawyering, but as an affront to the judicial system.
Knowing that history makes the exchange she had with Sabat on day 2 incredibly chilling.
It really does.
According to Law 360's coverage of the colloquy, she didn't just gently correct his rhetorical flair regarding the company's name.
No, she did not.
She instructed him, on the formal record, to go consult Quinn Emanuel, his own co-counsel in the broader OpenAI legal apparatus,
and to rigorously review the PTABA history before he proceeded any further with his narrative.
I mean, for a federal judge to tell an apex corporate litigator that he needs to go check his own firm's prior homework, that is a blaring judicial siren.
The instruction is a massive warning shot across the bow. But this raises an important question, right? We have to connect this warning to the actual mechanics of the trial to understand why it matters so much.
Right, like why is a judge's perception of OpenAI's credibility potentially more lethal than the jury's perception?
Exactly.
Well, this circles back to the logistical parameters we established at the beginning. The jury sitting in the box is an advisory jury.
Exactly. Under Federal Rule 39C, when a trial involves equitable claims, such as the enforcement of a constructive trust or claims of unjust enrichment, the judge is the ultimate fact finder, not the jury.
So the jury is just kind of a sounding board?
Essentially, yes. The judge can impanel an advisory jury to act as a focus group, to get a read on how everyday citizens interpret the evidence.
But their verdict is not legally binding on those equitable issues.
Right. The judge retains the power to make the final determination.
Therefore, OpenAI's defense strategy fundamentally relies on maintaining absolute credibility with Judge Gonzalez-Rogers.
Which is why the trademark contradiction is a 5-alarm fire. Let's examine the 3 load-bearing pillars of the defense Wachtell has constructed.
Okay, what's the first one?
First, they argue there was never a legally enforceable charitable trust created.
Second,
Second, they argue Musk's own 2017 emails suggest he was the one pushing for a for-profit entity, completely negating his current outrage.
And third?
And third, they rely heavily on the statute of limitations.
Okay, the statute of limitations, or SOL, seems to be where the credibility issue becomes most critical.
It really is.
Let's drill into the mechanics of that specific defense.
So the statute of limitations defense is basically a chronological shield.
Right. It doesn't argue that the defendant's actions were right.
Exactly. It just argues that the plaintiff waited too long to complain about them. The entire defense hinges on the discovery rule.
Which is what exactly?
It's the question of,
right.
When did Elon Musk actually know, or when should he have known, about the definitive plans to pivot OpenAI to a for-profit model?
So did the clock start ticking in 2017 during those initial equity disputes?
Or did it start in 2019 when the transition formally occurred?
Right. If the defense can prove Musk knew the nature of the pivot years ago, they can argue he slept on his rights and the 2024 lawsuit must be dismissed.
And this is the key, establishing that historical timeline requires the judge to completely trust the defense's curation of the historical record.
Oh, I see. The judge has to believe their interpretation of when conversations happened and what was intended.
Exactly.
I see the collision course now. If Wachtell loses their credibility with the judge because they attempted to massage the truth about their founding mission to sidestep a trademark contradiction,
they poison the well for their other arguments.
The judge might look at their carefully constructed timeline for the statute of limitations and decide she simply doesn't trust their version of events.
That is the structural threat of the credibility ledger. If the court absorbs the impression that the defense is willing to dynamically alter their founding history when it suits them,
then every single piece of evidence they present for the remainder of the trial will be scrutinized through a lens of profound distrust.
As Jack Russo meticulously details in his trial update, rhetorical exaggeration is somewhat expected and often forgiven during a dramatic opening statement to a jury.
Sure, lawyers spin things.
However, hyperbole that fundamentally contradicts the company's established legal history and requires an immediate correction from the bench transforms from a stylistic choice into a severe substantive liability.
So what does this all mean? If we pull back from the specific statutes, the Lanham Act disputes, and the individual evidentiary objections, what is the grand synthesis of Day 2?
The synthesis is that Day 2 was decisively won by Elon Musk.
And it is vital to understand that he did not win because his underlying legal theory regarding the charitable trust is impenetrable.
Right. As the trial progresses, the defense is going to aggressively deploy Musk's own late 2017 emails exploring for-profit avenues against him.
So he won because of an unforced error.
Yes. The day went to Musk because OpenAI's defense apparatus allowed their aggressive courtroom rhetoric to outpace their established documentary reality.
They presented a narrative that their own legal history simply could not support.
And the judge called them on it immediately.
Jack Russo's update concludes by offering actionable, strategic takeaways for the legal teams involved.
Which are super interesting.
Yeah, for OpenAI, the path forward requires immediate recalibration. The guidance is to abandon the hyperbole and retreat to the safety of the documents.
They need to stop characterizing Musk's actions as tantrums and start methodically displaying the contemporaneous notes from figures like Greg Brockman from late 2017 to rebuild the timeline.
Most crucially, they must reconcile the trademark discrepancy with the judge immediately and transparently.
Right, rather than attempting to litigate her warning.
And the advice for Musk's team is equally rigorous. Restraint is required.
The danger for a plaintiff in this scenario is overplaying a perceived advantage. The judge has issued her warning to the defense. The entry has been made in the credibility ledger.
So Musk's team does not need to turn the judge's colloquy into a theatrical centerpiece.
Exactly. They need to step back and let the documentary evidence speak for itself.
Because the true advantage comes from the bench quietly adopting the plaintiff's factual timeline because the defense has compromised their own.
Analyzing the mechanics of this trial reveals so much about the architecture of justice.
It really does. It reminds us that trials are rarely decided purely by who possesses the superior legal theory.
They are often decided by who manages to preserve the trust of the person wearing the robe.
And as we process all the legal maneuvers, the trademark disputes, and the dueling narratives of Day 2, it leaves us with a profound, lingering question to consider.
Yeah.
Think about the corporate landscape you interact with every single day. Think about the brands you buy from, the platforms you use, the services you rely on.
They all have these grand mission statements.
Right. But if a foundational, world-changing mission like promising to remain open and dedicated to the unmitigated good of humanity can be legally categorized by its own creators as merely temporary marketing the moment it becomes financially inconvenient.
Yeah. What does a corporate mission statement actually signify anymore?
Exactly. If an entity builds an empire by selling the public a key to the front door, does the law permit them to simply change the locks once the house is full?
It is the defining philosophical and legal conflict of the modern technology era, and we are watching the precedent being written in real time.
And we will continue to monitor every single motion, objection, and ruling as this trial unfolds. Thank you so much for joining us for this deep dive into the source material. The legal architecture may be complex, but by examining the mechanics, the strategies, and the history, we can start to see clearly through the muddy waters. We'll be back to decode the next chapter soon.
Tune in next time on The Valley Current.